Hello, friends, and welcome back to my channel, Advocate Pramod Bhardwaj Speaks. I'm Advocate Pramod Kumar Bhardwaj, and today we dive deep into the complex world of alimony and maintenance laws in India. As a practicing lawyer with over a decade of experience in matrimonial litigation, I've seen firsthand how these laws impact families across our nation. Let's begin by understanding the fundamental concepts of alimony and maintenance. While often used interchangeably, these terms have distinct legal meanings in Indian jurisprudence. Alimony typically refers to a lump sum payment made by one spouse to another after divorce, aimed at providing financial stability to the economically weaker spouse. Maintenance, on the other hand, is ongoing financial support that can be awarded during marriage, separation, or after divorce and may include support for children as well. The importance of these laws cannot be overstated. They serve as a safety net for economically dependent spouses, ensuring they are not left destitute after a marital breakdown. These laws reflect the Indian legal system's commitment to gender equality and social justice, recognizing the often unequal economic position of spouses in a marriage. The development of alimony and maintenance laws in India has been a journey of progressive reform. Historically, these laws were governed by personal laws of different religions. However, with the enactment of Code of Criminal Procedure in 1973, particularly Section 125, a secular provision for maintenance was introduced applicable to all Indian citizens regardless of their religion. For Hindu couples, the Hindu Marriage Act 1955 and Hindu Adoption and Maintenance Act of 1956 provide comprehensive frameworks for alimony and maintenance. Section 24 of Hindu Marriage Act allows for interim maintenance during divorce proceedings, while Section 25 provides for permanent alimony and maintenance after divorce. Muslim personal law also recognizes the right to maintenance, although historically limited to the iddat period after the divorce. The landmark Shah Bano case in 1985 extended this right beyond the iddat period, leading to the enactment of Muslim Women Protection of Rights on Divorce Act 1986. In recent years, the Protection of Women from Domestic Violence Act 2005 has further strengthened women's rights to maintenance, allowing them to claim monetary relief in cases of domestic violence. Now let's discuss some recent landmark judgments that have shaped the landscape of alimony and maintenance laws in India. In 2020, the Supreme Court, in the case of Rajneesh versus Neha, laid down comprehensive guidelines for determining the quantum of maintenance. The court emphasized that both parties must disclose their assets and liabilities in maintenance proceedings, ensuring transparency and fairness. Another significant judgment came in Mamta Jaiswal versus Rajesh Jaiswal, where the Madhya Pradesh High Court held that well-qualified spouses who choose to remain idle should not be encouraged to claim maintenance. The court emphasized that maintenance laws are not meant to create an army of idle persons waiting for financial support from their estranged spouses. It's crucial to note that maintenance is not gender-specific. While traditionally associated with wives, husbands can also claim maintenance if they are financially dependent on wives. Section 24 of the Hindu Marriage Act provides for maintenance pending light to either spouse who lacks sufficient independent income. The quantum of maintenance is determined based on various factors, including the income and property of both parties, the standard of living, and the financial needs of the dependent spouse and children. Courts have the discretion to award maintenance as a lump sum, monthly payments, or a combination of both. One of the most debated aspects of maintenance law is the concept of interim maintenance. This is financial support provided during the pendency of divorce proceedings. The purpose is to ensure that the dependent spouse can maintain themselves and meet the expenses of legal proceedings. However, it's important to note that interim maintenance is not automatic and must be justified based on the financial condition of both spouses. A recent trend in Indian matrimonial law is the concept of rehabilitative alimony. This is a form of temporary support aimed at helping the dependent spouse become financially independent. For instance, it might cover the costs of education or vocational training to enable the spouse to secure employment. It is also worth mentioning the concept of stridhan, which is distinct from alimony or maintenance. Stridhan refers to all movable property and immobile property given to a woman before, during, or after her marriage. The Supreme Court has held that woman has absolute ownership over her stridhan and can claim it independently of any maintenance proceedings. As we wrap up this discussion, it's important to remember that while these laws provide crucial protections, they are not without challenges. Issues such as delay in proceedings, difficulties in enforcement, and varying interpretations across different courts continue to pose challenges. For our next video in this series on matrimonial laws, we'll be discussing the grounds for divorce under various personal laws in India. This will provide a comprehensive understanding of the legal basis on which marriages can be dissolved in our country. I hope you found this information helpful and insightful. If you have any questions or need legal advice on matrimonial matters, feel free to reach out to me via WhatsApp or email. The contact details are in the description below. Don't forget to like, share, and subscribe to my channel for more such informative content on Indian laws.